वेलकम टू कानूनी चर्चा यूट्यूब चैनल। तो आज मैं बात करूंगा एक बड़ी इंपॉर्टेंट जजमेंट सुप्रीम कोर्ट ऑफ इंडिया की रिसेंट। ये जजमेंट है 23 ऑफ सितंबर 2024। इट इज रिलेटेड टू जुवेनाइल जस्टिस केयर एंड प्रोटेक्शन ऑफ चिल्ड्रन एक्ट 2015। तो इसमें क्या है, इस जजमेंट का टाइटल है स्टेट ऑफ मध्य प्रदेश वर्सेस राम जी लाल शर्मा एंड अदर। इसमें क्या था कि एफआईआर हुई। मैं डिटेल फैक्ट्स में नहीं जाऊंगा। जे 302 murder case, SC and ST Act. After lodging of investigation, a charge sheet was produced before the concerned special judge. Special judge, obviously session judge, because why special judge? Because there was offence, commission of offence. The accused was booked and are to be tried for commission of offence under SC and ST Act. So the challan was produced, the charge sheet was produced after investigation before this special judge. Special judge, after a trial, convicted the accused and accordingly sentenced. Thereafter, obviously the accused went in appeal and they were acquitted in appeal by the Honorable High Court. Afterwards, what happened? The state approached the Supreme Court of India by way of criminal appeal. In criminal appeal, Supreme Court of India reversed the judgment of Honorable High Court, and again they were convicted and sentenced accordingly. The earlier, you can say the judgment of session judge was upheld. Session judge judgment was conviction and sentence. I'm not going to in detail. Today my concern is with regard to this Juvenile Justice and Care and Protection Act, this 2015। इसमें क्या था कि एक जुवेनाइल, वो भी जो ट्रायल कोर्ट ने भी उसको कन्विक्ट कर दिया, हाई कोर्ट ने तो इन रेगुलर जो भी उसके पास थी, जो अपील थी, उसमें सभी को अक्यूट कर दिया। आफ्टरवर्ड्स जो क्रिमिनल अपील में सभी को दोबारा कन्विक्ट कर दिया, सेंटेंस कर दिया सुप्रीम कोर्ट ऑफ इंडिया। लेकिन किसी ने प्ली पर्टिकुलर जो जुवेनाइल था, जो चाइल्ड था, उसने रेज ही नहीं की। नोवेयर, नाइदर ड्यूरिंग ट्रायल नॉर इन एनी ऑफ द criminal appeal, you can say, there is neither before the High Court nor before the Supreme Court. After conviction by the Supreme Court of India of all the accused, including the juvenile, what happened after he was undergoing this sentence in concerned jail, the judge who has raised the plea after his conviction along with other accused and sentencing by the Supreme Court of India, he filed an application before the Supreme Court of India, obviously making a claim that he is a juvenile within the meaning of this Juvenile Justice, Care and Protection of Children Act 2015. This application was entertained by Supreme Court of India, and this special judge, session judge, was directed to have an inquiry as to his age, the plea claim raised before the Supreme Court of India. तो सुप्रीम कोर्ट ऑफ इंडिया के पास ये एप्लीकेशन लगी है, और वहां पे उन्होंने एक इसमें से जो जुवेनाइल था, जो चाइल्ड क्लेम कर रहा था, तो उसने हम अपने आप को कहा कि मैं जो आई एम बिलो 18 ईयर्स ऑफ एज, तो अकॉर्डिंगली वो एप्लीकेशन में डायरेक्शन होगी, जो स्पेशल जज जो भी कंसर्न सेशन जज, तो उसने इंक्वायरी की एज तो उसने क्या किया, दो एजेस आ गई, उसकी एज थी, एक एज आई थी जो उसकी जो बर्थ स्कूल रिकॉर्ड था, दूसरा था जो उसका आधार कार्ड। ऑब्वियसली जो सेक्शन 94 है ऑफ जुवेनाइल जस्टिस केयर एंड प्रोटेक्शन ऑफ चिल्ड्रन एक्ट 2015, उसके मुताबिक तो स्कूल रिकॉर्ड इज टू बी प्राइवेट। इफ अदर फर्स्ट इज दैट देयर शुड बी ए the regard to his age, birth registration before police or before municipal authority or any other authority where his birth is recorded originally. If and subsequently the school record, admission record can also be considered. This is this section 94. I'm not going into detail, but upon the question rises, the state resisted, state of the council before the Supreme Court happened. They resisted that such a plea was not raised before any court, neither nor before the this court of session, special judge, nor before the High Court, and not before the Supreme Court of India. Now this is a belated stage, but Supreme Court of India allowed the prayer and directed the session judge to have a inquiry as to age of the, by taking into consideration, there are very two judgments, important judgments. You will find in para 9, this is Abu Jar Hussain versus State of Bengal. इसमें क्या था, उन्होंने कहा कि जुवेनाइलिटी मे बी मेड, द प्ली ऑफ जुवेनाइलिटी, क्लेम ऑफ जुवेनाइलिटी कैन बी मेड एट एनी स्टेज ऑफ क्रिमिनल प्रोसीडिंग and even after final conviction and sentence. This was a plea raised before the Supreme Court of India. The para 11 is very important. This where the Honorable Supreme Court has considered the judgment. This is, and also facts of the case touching Juvenile and Justice Act and other provisions. So I will read out for the convenience of this episode. It is noted that in respect of incident dated, the incident was 17th of January 2002. The applicant was convicted on 24 of February 2006 by the special session judge Bind. Thereafter, he was acquitted by the High Court by judgment. It is dated 13th of December 2018. Subsequently, in the appeal filed by the respondent state, this court means Supreme Court of India, by judgment dated 9th of March 2022, convicted the applicant. It is thereafter that the applicant has undergone sentence of 4 years and 3 months. I have already said that after conviction and sentence by the Supreme Court of India, he was in jail, and subsequent thereupon this application was filed, which was considered. It is thereafter that the applicant had undergone sentence of 4 years and 3 months in all. Subsequently, this miscellaneous application, which is being decided by this order, judgment, you may say, this miscellaneous application was filed, and this court, Supreme Court of India, by its order dated 16th of May 2024, directed that inquiry be conducted. Subsequently, the learned session judge has passed his order on 16th of July 2024 and has submitted his report to this court, means Supreme Court of India. Afterwards, pursuant to the order of this court, on 16th of May 2024, the applicant has been released on interim bail after getting a this on the after getting, or that when the direction was made before to the on the that day he was released on bail. These are facts of the case and the proceeding, how proceedings and what has happened on a particular date, that has been reflected in this para. Therefore, on perusal of this report, my report submitted by the special session judge, we note that not only the applicant herein, but mother as well as headmaster of the school have been examined. There in inquiry by the special judge, he has examined some witnesses, headmaster of the school, and mother of the child. It is on consideration of the same, having regard to section 94. I have already referred that juvenile, this section deals with inquiries, how inquiries to be conducted, what are the evidence, what are the documents to be considered while as to for determination of the age of the child. The learned session judge found that the applicant was below 18 years of age as on the date of incident. So, definition of child and definition of juvenile, you will find in Juvenile Justice, Care and Protection of Children Act 2020, that is below 18 years. If somebody is below 18 years, so then his case comes under this act. Now, the Honorable Supreme Court have also taken assistance of another judgment. They have referred here in this para 11. Although the application has been filed subsequent to the conviction ordered by this court, after there was a conviction in criminal appeal, and after and simultaneously, you can say the sentence already. We have regard to the judgment of this court as noted above, and in judgment dated 17th of January 2004 in criminal appeal number as title of the this criminal appeal was Pramila versus State of छत्तीसगढ़. उस केस में भी वैसा ही था जैसे इस केस में है. तो उसने क्या, दैट एन एप्लीकेशन फॉर क्लेमिंग जुवेनाइलिटी may be made even after judgment and order of conviction. तो ये प्रोमिला वर्सेस स्टेट ऑफ छत्तीसगढ़ में सुप्रीम कोर्ट ऑफ इंडिया ने एक अपना वर्डिक्ट दिया था कि जो कन्विक्शन होने के बाद, सेंटेंस होने के बाद जे प्ली रेज हो सकती है, क्लेम किया जा सकता है और उसको जे भी लो भी किया जाता है, कंसिडर भी किया जा सकता है. तो जे भी pursuant to the direction of this court, we find that date of birth of the applicant has been proved to be 4th of October 1984. Consequently, the claim of juvenility made by the applicant who was arraigned as accused number 3 is upheld and conviction as recorded against him by this court is set aside and he stand acquitted as he is on interim bail, his bail bonds stand cancelled. Consequently, the miscellaneous application is allowed in the aforesaid terms. This judgment is of two judges bench. Judges bench was B.V. Nagaratna, Justice, and Justice N.P. Koteshwar Singh. This is dated 23rd of December. I have discussed here. Crux of the matter is that it is in the interest of justice, or otherwise the court, trial court, and this stakeholders in the administration of justice, particular criminal justice, must be careful that plea of juvenility must be looked into at the stage of investigation first by the police. And the relevant record must be sought where apparently the accused appears to be this child, you can say, conflict with law. After that, if that factor is ignored by this investigating agency, trial court must have taken care of that. If was occurrence was of 2002, I think, and this conviction by the trial court is in the year 2006. How long? I think 22 years proceedings and undertaken in this matter against the child juvenile, and he remained in jail for about 4 years, as I have referred here earlier. Say the litigant is not knowing all this. What is law? No doubt, ignorance of law is no excuse. But such police who are expert, the lawyer, the police, the judges must be careful, so that at the earliest this plea may be raised and taken into consideration and acted upon this. Had this been done in this case, the 22 years, you can say, would have been saved. If there would have been trial, he would not have gone. So he might have been dealt with on Juvenile Justice Care and Protection Act, what are the relevant provisions, जो भी उसके relevant provision वहाँ हैं, उसके मुताबिक उसको डील किया जाना था. तो मुझे लगता है, तो ये जजमेंट मेरे नोटिस में आई, तो मैंने इसको कहा कि ये बड़ी इंपॉर्टेंट जजमेंट है जो एक्सरसाइज की गई है, और पर्टिकुलर कि जो प्ली क्लेम ये किसी भी स्टेज पे होता है, कन्विक्शन सुप्रीम कोर्ट की भी जहाँ पे हुए उसके बाद भी रेज किया जा सकता है. तो ये कोई नहीं है कि ये एज ए इनिशियल स्टेज जो ट्रायल कोर्ट के पास ही करना चाहिए, ये कहीं भी रेज हो सकता है. तो मुझे लगता है ये काफ़ी आज के लिए. थैंक यू वेरी मच.